Good day, madam. My name is Ravina, and I'll be doing a solo presentation. The first issue is whether Adam's promise of RM 500,000 and the Ford Mustang gift constitute binding contracts given Suhaimin's pre-existing engagement with Sri Devin. There are two laws that are applicable here, which is Section 2D and Section 10, Clause 1 of the Contract Act 1950. Section 2D of the Contracts Act 1950 states that when at the desire of the promiser, the promisee or any other person has done or abstained from doing or does or abstain from doing or promises to do or abstain from doing something, such act or abstinence or promise is called a consideration for the promise. According to Section 10, Clause 1 of the Contracts Act 1950, all agreements are contracts if they are made by the free consent of the parties competent to contract or a lawful consideration and with a lawful object and are not hereby expressly declared to be void. In the case of Re McArdle 1951 concerned a house which was the joint property of several siblings in which they lived together. The plaintiff, the wife of one of the brothers, paid for repairs to the house. After that, the siblings agreed with the plaintiff that in consideration for the repairs, they would pay her $488. Subsequently, the plaintiff sued for the payment of the $488, the defendant in the suit being the siblings other than her husband. The issue was whether there was consideration for this agreement to pay her the $488. The Court of Appeal held that as the repairs had been carried out before the agreement to pay had been made, it was past consideration and therefore not good consideration. In the case of Stilk against Myrick 18-9, the court upheld the principles that the performance of a pre-existing contractual duty does not constitute valid consideration for a new promise. The case involves a seaman who, under an existing agreement, had agreed to work on a voyage from London to the Baltic and back. When two crew members deserted, the ship's master promised to distribute their wages among the remaining crew, including the plaintiff, if they continued their duties. However, upon their return to London, the master refused to pay an additional sum. The court dismissed the plaintiff's claim, holding that the seamen were already contractually obligated to perform their duties, including managing unforeseen emergencies, and thus the master's promise of extra payment lacked consideration. Lord Ellenborough emphasized that the mariners had already sold their services for the entirety of the voyage, rendering the new agreement void. Applying Section 2D of the Contracts Act 1950 to the current case, it allows for consideration to include past acts at the promiser's request. However, Suhaimin's actions were not performed at Adam's request but were already intended, making the promise unforceable. Suhaimin's actions were not performed at Adam's request but were already intended, making the promise unforceable. Under Section 10, Clause 1 of the Contracts Act 1950, for Adam's promise of RM 500,000 to be valid contract, there must be lawful consideration. Suhaimin's pre-existing engagement with Sri Devin indicates that his subsequent marriage was not performed at Adam's desire. Thus, no lawful consideration exists to make the promise enforceable under this section. The absence of mutual promise or an exchange of obligations means the Ford Mustang gift does not meet the requirement of lawful consideration under Section 10, Clause 1. It is a voluntary act and not a contractual act obligation. Following the case of Re McArdle, Suhaimin's pre-existing commitment to marry Sri Devin means no new consideration arose from Adam's promise. This is further supported by Stilk v. Myrick, which emphasizes the performing an existing duty cannot be valid consideration. Applying Section 2D of the Contracts Act 1950 to the current case, it allows for consideration to include past acts at the promiser's request. However, Suhaimin's actions were not performed at Adam's request but were already intended, making the promise unforeseeable. Suhaimin's actions were not performed at Adam's request but were already intended, making the promise unforeseeable. Under Section 10, Clause 1 of the Contracts Act 1950, for Adam's promise of Rm 500,000 to be valid contract, there must be lawful consideration. Suhaimin's pre-existing engagement with Sri Devin indicates that his subsequent marriage was not performed at Adam's desire, thus no lawful consideration exists to make the promise enforceable under this section. The absence of mutual promise or an exchange of obligations means the Ford Mustang gift does not meet the requirement of lawful consideration under Section 10, Clause 1. It is a voluntary act and not a contractual act obligation. Following the case of Re MacArdle, Suhaimin's pre-existing commitment to marry Sri Devin means no new consideration arose from Adam's promise. This is further supported by Stilk v. Myrick, which emphasizes the performing an existing duty cannot be valid consideration. In conclusion, Adam's promise of Rm 500,000 and the gift of a Ford Mustang do not constitute binding contract due to the lack of lawful consideration. Suhaimin's pre-existing engagement to Sri Devin means his action, including his marriage, were not performed at Adam's request, thus failing to fulfill the requirements of Section 2D of the Contracts Act 1950. Additionally, under Section 10, Clause 1, the absence of mutual promises or obligation renders Adam's promise unforeseeable, as the gift offered do not create a contractual obligation. The principle established in Re MacArdle and Stilk v. Myrick further reinforced the idea that pre-existing duty or an act cannot serve as valid consideration for a new promise, leaving both promises void. The second issue is whether Yuna has legal capacity to enter into the contract, which makes her legally bound under the contract. According to Section 10, Clause 1 of the Contracts Act 1950, the capacity of a party to enter into a contract is an essential element for the formation of a valid contract. The provision states that all agreements are considered contracts if they are entered into among the other requirements by parties competent to contract. The question is, who is competent to contract? Section 11 of the Contracts Act 1950 provides that every person is competent to contract who is, first, of the age of majority according to the law which he is subject, second, sound of mind, and third, not disqualified from contracting by any law to which he is subject. Pursuant to Section 2 of the Age of Majority Act 1971, the age of majority is defined as 18 years old. Section 2 of the Age of Majority Act 1971 states, subject to provisions of Section 4, the minority of all males and females should kiss and determine within Malaysia and the age of 18 years, and every such male and female attaining that age should be the age of majority. Section 4 of the same Act provides that nothing in the Act shall affect, first, the capacity of any person to act in matters such as marriages, divorce, dower, and adoption, second, the religion and religious rights and usages of any class of a person within Malaysia, third, any provisions in any other written laws that fixes the age of majority for the purposes of that written law. Minors generally lack of legal capacity to enter into binding contract, as seen in Mohori Bibi v. Dormodas Goes 19.3, where a loan agreement involving a minor was declared void. Similarly, in Halijah against Morad 1972, agreements imposing financial obligations on minor were unforeseeable. However, Section 4 of the Contracts Amendment Act 1976 allows scholarship agreements to remain valid despite the minor's age. The term scholarship agreement as defined in Section 2 of the Act includes contracts for education or learning involving sponsorship or financial support. Before this amendment, cases like Government of Malaysia against Gurcharan Singh 1971 voided such agreements based on minority, though minors were held liable for necessary like education costs. Post-amendment in University of Malaya against Lee Ming Chong 1986, the court upheld a scholarship agreement requiring Lee to serve the university for 5 years after studying in Canada. When Lee breached the agreement, resigning prematurely, the court ruled in favor of the university, awarding $5,000 as compensation for the breach, emphasizing the enforceability of scholarship agreements under the amended Act. Under Section 10 and 11 of the Contracts Act 1950, minors generally lack the legal capacity to enter into binding contracts, rendering such agreements void. However, Section 4 of the Contracts Amendment Act 1976 provides an exception for scholarship agreements, making them valid despite the minor's age. In the case of Yuna, a 16-year-old minor, her agreement with Adam to work for the company in exchange for a scholarship to study in France qualifies as a valid scholarship agreement under this provision. The mutual consideration of financial sponsorship for education and Yuna's promise to render service upon completing her studies satisfies the enforceability criteria. This interpretation aligns with the decision in University of Malaya against Lee Ming Chong and reflects the educational purpose of the arrangement, overriding the general prohibition against contracts involving the minors. In conclusion, while Yuna would generally lack the capacity to enter into a binding contract under the common law principles, the scholarship agreements with Adam is valid and enforceable under Section 4 of the Contracts Amendment Act 1976. As such, Yuna is legally bound to fulfill the terms of the agreement, including the obligation to work for Adam's company upon completing her studies. The third issue is whether Yuna can initiate action against on behalf of Suhaiman against Adam. The law that is applicable here is Section 2D, which says that consideration is something of value that is exchanged in contract. It can be an act, a promise to do something, or a promise not to do something. For a contract to be valid, both parties must give or promise something in return for the other's offer. Consideration is what makes the agreement legally binding. In the case of Kepong Prospecting Limited, the respondent helped Mr. Tan obtain a prospecting permit, and Mr. Tan promised to pay the respondent a 1% tribute from the sale of iron. Later, the appellant company took over Mr. Tan's obligation to pay this tribute. In 1955, the company made an agreement with the respondent to pay the 1% tribute. The appellant then claimed the payment from the respondent under the both 1954 and 1955 agreement. However, the court ruled that since the respondent was not part of the 1954 agreement, he could not enforce it. While third parties can provide consideration, only the parties directly involved in the contract can sue to enforce it. In Beswick against Beswick 1968, a man sold his coal merchanting business to his nephew, with the nephew promising to employ the descendant as a consultant and to provide an annuity to the descendant's wife after his death. After making the first payment, the nephew refused to continue the annuity payments. The widow, acting both as the administratrix of the husband's estate and in her personal capacity, sued the nephew for specific performance of the contract. The House of Lords ruled that the widow could not enforce the contract in her personal capacity, even though it was clear she would benefit from it because she was not a party to the original agreement. In the case involving Yuna and Adam, the key issue is whether Yuna can initiate legal action on behalf of Suhaiman against Adam for failing to honor his promises, including the scholarship agreement and the RM500,000 incentive. Under Section 2D of the Contracts Act 1950, for a contract to be legally binding, both parties must provide consideration. While Yuna may be a beneficiary of the scholarship agreement, as shown in Kepong Prospecting Limited and Bestwick against Bestwick, third parties who are not parties to the original contract typically cannot enforce its term. In Kepong, the respondent could not enforce the contract because they were not part of the initial agreement, and in Bestwick, the widow could not personally enforce a contract despite being the intended beneficiary. Similarly, since Yuna was not directly a party to the agreement with Adam, she would likely be unable to initiate legal actions to enforce it on behalf of Suhaimin. She would need to demonstrate a legal exception, such as a clear third party beneficiary clause, to have standing to sue. In conclusion, Yuna cannot initiate legal actions on behalf of Suhaimin against Adam for the RM500,000 promise because of the doctrine of privity of contract. Suhaimin must bring the claim himself. Furthermore, Adam may argue that the promise is unenforceable due to misinterpretations and lack of consideration. The fourth issue is whether there are any possible remedies for Adam. Section 66 of the Contracts Act 1950 applies when an agreement is found to be void or a contract becomes voidable due to legal defects, for example, misinterpretations and mistake. If a contract is found to be void or unenforceable, the party who received an advantage may be required to restore the benefits received or compensate to the other party. The case of Ng Sui San against Menaka illustrates the application of Section 66. In this case, the federal court held that the respondent was entitled to restitution because she was unaware of the agreement's illegality when it was executed. The court ordered the return of the specified amount to the respondent, emphasizing that Section 66 applies if the party seeking relief was not complicit in or aware of the illegality. This principle demonstrates that restitution is possible under a void or voidable agreement provided the conditions of Section 66 are satisfied. If the agreements are declared void or voidable, Section 66 of the Contracts Act 1950 becomes applicable, requiring Adam to restore any benefit received under the contracts, such as the Ford Mustang or other advantages granted by Suhaimin and Yuna. Drawing parallels to Ng Sui San against Menaka, if Adam was unaware of the defects, misinterpretations or illegality at the time of forming the agreements, he could invoke Section 66 to seek restitution or argue for a reduction in liability, emphasizing his lack of knowledge and financial incapacity. These measures may help Adam manage his obligation and negotiate a resolution with Suhaimin and Yuna. In conclusion, Adam's remedies depend on proactive negotiation and the application of Section 66 of the Contracts Act 1950. To mitigate potential claims, Adam could attempt to renegotiate the agreement to reduce his obligations or extend the timeline for performance. If the agreement is found void or voidable, Adam must restore the benefits received under Section 66 unless he can prove unawareness of any illegality at the time of the contract formation. Applying the case of Ng Sui San against Menaka, Adam's lack of knowledge regarding defects in the contract could serve as a defense for restitution's claim. Ultimately, renegotiation and cooperation with Suhaimin and Yuna are the most viable strategies to minimize liabilities and maintain the business relationship. That is all from me. Thank you.